Hi, everyone. This is Conn Maciel from Conn Maciel Carey. I'm happy that you're able to join us today for this really challenging and difficult topic of how employers should respond to the COVID outbreak that is spreading across America. We here at Conn Maciel Carey have a unique boutique nature. Our firm is focused exclusively on labor and employment and OSHA workplace safety issues. And so I don't think there could be a better firm that really has the expertise across all of our practitioners to be able to answer some of the burning questions that you guys are facing today and over the next several weeks as this develops. A little introduction about me. I am a partner here, founding partner here at Conn Maciel Carey, and I chair the Labor and Employment Practice Group. So I do everything from advising employers on the soups to nuts of the employment relationship, a lot of counseling about what's happening today, policies, procedures in the hiring and firing of employees, as well as defending employers in litigation across the country. I also advise employers on their issues under the National Labor Relations Act to the extent that you've got facilities that are unionized. That has a unique layer with everything that you're thinking through right now with respect to your workplace. With that, I'll turn it over to my partner, Eric Conn.
Thanks, Kara, and thanks everybody for joining us. I wish we had a more pleasant topic to be talking about than this crisis that is on our hands that we're all dealing with, I'm sure, in unique ways. I'm Eric Conn. I'm one of the co-founding partners of Conn Maciel Carey. I chair the firm's National Workplace Safety and Health Practice Group, where my practice focuses on all aspects of OSHA law, from principally representing employers in their dealings with OSHA, state OSHA plans, and federal OSHA through inspections, investigations, and enforcement actions. But also, since we started our firm 5 years ago in this smaller platform, we're able to do more really a soup to nuts practice on the OSHA front, helping employers develop compliant policies, training, auditing, and really helping our client partners navigate through crisis situations like this. But that's the introduction of me, and if you missed it, probably all the better for your ears. But I look forward to talking with you today about the OSHA implications of this crisis.
Hi, my name is Amanda Walker. I'm also a member of the OSHA practice group and have been practicing with Conn Maciel since its inception. I have been practicing exclusively OSHA law and was actually at the Department of Labor when some of the SARS guidance was issued, and have worked around that and have been helping out with our response to this virus. I deal with all things that are OSHA related, from compliance to litigation and enforcement. I'll turn it over to Lindsay.
All right, good afternoon, everyone. I'm Lindsay DeSalvo, and I am an associate here at Conn Maciel Carey in both the firm's OSHA practice as well as our labor and employment practice. So I've had experience dealing with this issue from both sides. Both the employment implications that have been coming up as the situation develops, as well as some of the safety issues that have arisen, the questions related to those as well. I do a lot of work in wage and hour, claims of discrimination, and the Americans with Disabilities Act, all of which we'll talk a little bit about today and have definitely been implicated in this developing situation. And then I also, on the OSHA side, help with inspections and investigations, as well as providing safety advice and counsel. And I will then turn it back over to Kara to get started on our presentation.
Okay, thanks everybody. So here's the agenda for the next 45 minutes to an hour. We're going to talk a little bit about the coronavirus and how employers are affected. This is a moving target every day. The data changes, but just want to lay a little bit of a base about what we know about the virus and how it spreads. Then I'm going to focus with Lindsay on the labor and employment implications. We'll cover the ADA. I'm getting a lot of questions about what employers can do during a pandemic, and we'll talk a little bit about that in terms of the kind of questions you can ask your employees if they are exhibiting symptoms. We'll also touch on Title VII non-discrimination implications, as well as some wage and hour questions, and then close with some FMLA and sick leave questions, especially in light of the House bill that has been passed in federal legislation and is pending in the Senate, and what employers need to know about those provisions. Then we'll turn it over to Eric and Amanda, and they're going to talk about the OSHA implications, including the infectious disease rule, since COVID is an infectious disease, what your obligation is, every employer's obligation is under the General Duty Clause, some respiratory protection issues, and I know that Eric and Amanda have been fielding a lot of questions on record keeping to the extent that COVID appears in the workplace and what you need to do to report it. And then I will close with the CDC guidance and best practices and open it up to questions as you have them. So let's just jump right in with the coronavirus. This is changing, obviously. This is as of yesterday. It has been moving around the world. We've seen Europe being a hot spot. China obviously is a hot spot, and it's growing in the United States. In the United States, I'm seeing reports of over 5,000 cases now being reported. I think I just saw something come across the newswire about 5,600 cases. States are reporting their cases at their state Department of Health, which is a really good resource to know what's happening in your county and in your state. You can also, of course, go to the CDC's website. They are updating their information daily. I think every day at the same time around 4, but states are also, as I mentioned, updating their information. So as we see, it's continuing to spread with hot spots in, Seattle, California, New York, and continuing to grow as well. How coronavirus is spread. A lot of this information has been shared, so I won't repeat it. I'll go through quickly, but primarily it's thought to be spread person to person. It's not necessarily airborne, but it is through people who are in close contact with one another, so often through respiratory droplets that are produced when someone coughs or sneezes. It is possible to get COVID by touching the surface of an object that has the virus on it, and I'm not a medical professional, but I've been hearing a wide-ranging view of how long the virus stays on a particular surface, depending on the nature of that surface, the humidity in the room, but certainly the point is you want to make sure you're not touching your mouth or your nose or your eyes while also touching other things. That's not the main way the virus is thought to be spread, which is really why it is more the close contact with people and the community spread issues that we're seeing as the way to try and contain it. Symptoms of the coronavirus, this is very different than the allergies that a lot of people are experiencing right now, given the pollen that's happening with springtime. It's very different from the common cold. We're looking at symptoms that include a fever, chills, a cough, difficulty breathing, headaches, and just, the general feeling of being unwell. But beyond that, you've got to have something similar to fever, cough, headaches, although you don't necessarily have to have a fever, but fever is very prevalent. The incubation period is approximately 14 days. Again, I'm not a medical professional, but generally that's what the medical professionals are saying, during which time an individual may see no symptoms but can be contagious, which is why we're hearing now from the administration that it's a 15-day period to stop the spread of the virus and to really limit your community contact. At the workplace, there's higher level of risk for exposure for individuals that work in a variety of different types of industries. Certainly healthcare has the highest risk, including medical providers, clinicians, support staff, customer care representatives within a clinic or doctor's office. Workers dealing with deaths, including coroners and medical examiners, funeral directors. Certainly seeing airline operators, the airline industry taking a huge unfortunate hit as a result of the spread of the coronavirus, waste management, and then just generally travel. So to the extent that you have employees that have traveled to areas including parts of China, now Europe, now Italy, other parts of the country. Egypt, we saw some people who were affected from the Nile River cruises. So in addition to industries, you've got to think about your employees who may be returning to the workplace from a personal vacation or work-related vacation. So with that general background, let's touch right in what everybody's questions are about, and that's really the implications of coronavirus from a labor and employment perspective. So the first thing I want to talk about is the Americans with Disabilities Act. This is the federal ADA that governs all workplaces with more than 15 employees. And what the ADA does is it protects applicants and your employees from disability discrimination. And it regulates what type of questions that you can ask related to an employee's disability or the type of exams that you can ask people to undergo during their employment. You can't ask individuals with disabilities, or you can't exclude individuals with disabilities from the workplace for health or safety reasons unless they pose a direct threat. And then, of course, to the extent someone has a disability, you need to provide reasonable accommodations for individuals. Unclear whether the coronavirus would be considered a disability because they're supposed to be, people are supposed to recover from it, but certainly long sickness and being in quarantine could be considered a disability. So a lot of questions have come up in terms of what can I ask my employees about their illness or their symptoms, and can I ask them to take certain medical tests? So an inquiry is disability related if it's likely to elicit information about a disability. So if you were to ask someone who was calling in sick what their symptoms is, generally that could ask or elicit information about a disability that's generally prohibited. A medical exam is a procedure or test which seeks information about someone's physical impairments or their health. So applicants, you cannot either inquire or do exams under the ADA. After someone who has been conditionally offered employment, you can ask certain questions and conduct exams if you're doing that across all new hires for that position, and you've got the same questions and same exams for that position. But for everyone on the call, mostly you're concerned about your current employees, and generally during employment, inquiries and medical exams are prohibited unless they're job-related and consistent with business necessity. So let's drill down a little bit on that. Can you ask your employees to report their illnesses to your supervisors right now? Absolutely. If someone is unable to report to work because they're sick, you absolutely can require them to notify his or her manager before the start of their shift. Generally, if we're not in a direct threat analysis, you should not be asking employees to disclose the nature of their illness at the time of the absence for privacy reasons, because that generally would not be required for a job-related or business necessity. However, if there becomes a direct threat, you can ask more questions and conduct further exams. And a direct threat is defined as a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. And under the ADA, there are 4 factors that courts consider in determining whether an employee poses a direct threat. And for purposes of today, just about the coronavirus, we're looking at the duration of the risk, which seems like it could be weeks or longer, the nature and the severity of the potential harm. Here we're looking at significant illnesses, significant flu-like symptoms, fevers, up to the potential for death. Third, the likelihood that potential harm will occur. That really is evaluated based on close contact and other factors based on your workplace, and the imminence of the potential harm. So the question is COVID-19 a pandemic? And this has been a question that we have been really struggling with over the last couple of days because there's been a lot of inconsistency between the World Health Organization and the CDC. But we've got some pretty good information today that really, as of March 11th, the World Health Organization declared COVID as a global pandemic. And what the World Health Organization says is pandemics start with an investigation phase. Then it's followed by recognition, initiation, and acceleration phases. The peak of illnesses occurs at the end of the acceleration phase. This is often where you're seeing the curve, the big spike in the curve that the media is reporting. And then it follows with a deceleration phase, during which there's a decrease in the illness. The CDC, who is in charge of regulating in the United States, what they've been saying is, look, different parts of the country are seeing different levels of COVID activity. And we saw that at the beginning with our slides of the states showing that hot pockets like New York and California are seeing that very different than, other states like Oklahoma or Hawaii or Alaska or things of that nature. And according to the CDC, the U.S. nationally is currently in the initiation phase, which is the third phase of the pandemic, where other states where community spread is occurring, they're in the acceleration phase. And because those phases are part of the definition of pandemic, we understand that COVID is a pandemic. And in fact, our office has been in contact with the CDC's legal office. And while there's no formal means for the CDC to specifically declare a pandemic, they follow the WHO for pandemic designation. And so that's really what's important to be following and why it's relevant, because it has a lot to do with what you can do in the workplace with respect to your employees and the type of information that you can ask and the medical tests that you can inquire about, because once it's a pandemic, that automatically meets the direct threat analysis under the Americans with Disabilities Act. In addition, we have the EEOC, who enforces the Americans with Disabilities Act. They recently, over the weekend, released technical guidance about pandemic planning in the workplace, and they answer a lot of questions. We did a blog post about this, and you can find that on our website, but their guidance is called What You Should Know About the ADA, the Rehabilitation Act, and the Coronavirus. And what they have done is they have relied on their prior guidance that they issued back in 2008 about pandemic preparedness in the workplace and the Americans with Disabilities Act. And they answer a lot of questions in terms of what employers can do, and what it states, and which is good, it gives you a lot of additional steps of what you can do now that we're in the United States and responding and preparing for this pandemic, including how much information you can ask from employees who are calling in sick to protect the rest of the workforce, when you can take employees' temperature, and whether you can require employees to stay home if they have symptoms. We're going to answer these questions going forward. So first, can you encourage your employees to stay home if they are sick? Absolutely, and you should be doing so. The CDC is recommending that employees with symptoms of acute respiratory illness should not go to work until they are free of fever, which is defined by 100.4 degrees Fahrenheit, or signs of a fever, or any other symptoms for at least 24 hours without using fever-reducing or other symptom-altering medicines. For those of you with children, you probably know that's a very common requirement of any child care facility or public school. You can't send your kid back to school without them being fever-free, and can't give them Tylenol to try and mimic their flu-like symptoms. Same thing here in the workplace. Absolutely do not allow your employees to come back to work until they are free of a fever. And they certainly should be notifying management and staying home if they are sick. You can, now that it's a pandemic, you can, if someone calls in sick, you can ask them more questions whether they're experiencing certain influenza-like symptoms. So if someone calls in and just says, I'm not feeling well, now that we're in a pandemic situation, you are under the ADA able to ask them, are you experiencing a fever? Are you experiencing chills or cough or sore throat? If you do that, just make sure that any information that you get from an employee about their illness is kept as a confidential medical record. Don't distribute it widely within your workplace. Don't disclose the employee's name who doesn't need to know. It should be kept in a confidential HR file. You can refer to the individual as the individual using the pronoun there, so that you're not identifying the gender pronoun of the individual. What else can you do now that we're in a pandemic? Certainly you should require infection control practices at work. Regular hand washing, coughing, sneezing, proper tissue usage. Consider using liberal sick leave policies to allow infected employees to stay home. I know that in the last 24 hours, we have started to see a lot of localities require businesses to close or to not operate if they are not essential. And so you'll need to be thinking about sick leave policies or other types of policies to the extent that not only do you have sick leave infected employees, but also potentially employees that are affected by these shelter-in-place orders. And as I mentioned, you want to keep all medical information confidential and separate from your other personnel records and files. One of the questions we've been getting recently is, can I take my employees' temperatures to determine whether they have a fever? This question is specifically answered in the EEOC's guidance that I referred to earlier. And what they're saying generally, as I mentioned, absent a direct threat, the ADA restricts you from taking your employee's temperature because that's considered a medical exam. You could, however, ask an employee to voluntarily monitor their own temperature if you'd like. But now what the EEOC is saying is if they have pandemic symptoms, flu-like symptoms that are more severe than the seasonal flu, or if pandemic influenza becomes widespread in the community as assessed by state and local health officials or the CDC, you are able to measure employees' body temperatures. So here I would look at how the community spread is affecting your locality because, as I mentioned, one location might be different than another location based on the community spread. But certainly you can rely on the state and local health authorities' assessments and the CDC in the determination that it is a direct threat and allows you to measure body temperatures. If you're going to do that and implement a policy of taking employee temperatures, then you must make sure you're applying that consistently across job duties, maybe across job classifications, and not targeting individuals or employees based on other protected categories like their national origin or their race. Importantly, employees who have COVID-19 may not experience all symptoms of the virus, such as a fever, as I mentioned earlier. So you really want to be also cognizant of monitoring the other symptoms like chills and a cough, as we mentioned. What about other questions you can ask? You can ask people about recent places of travel, including personal travel. If someone has traveled recently to Europe or to other parts of the United States, including New York or Seattle, where those are hotbeds, you want to ask them those questions. You want to be able to ask them if they've been there, and you can take steps to self-quarantine them, self-isolate them if they have traveled there. As I said, you require people to get treatment if they're showing symptoms of the disease. Ask inquiries about their symptoms. Tell them to contact their primary care physician, which is what the CDC is saying, is that they shouldn't go immediately to the emergency room. They should contact their primary care physician, who will give them more detailed information about what to do next. Certainly, if you have people who are developing symptoms, they need to leave the workplace for at least 14 days or longer to see if it ultimately results in a positive COVID-19 diagnosis. And then think about what your policies are going to be with respect to compensating individuals who may have to stay home during that incubation period, or if people are staying home because they have to telework or they're not able to come to work because they are in a location where they are not an essential functioning business and can't report to work. The other question we get a lot about is asking whether you can require your employees who've been out to require a doctor's note. And the question is yes, and you should, certainly for anyone who has had a positive diagnosis of COVID-19. But to the extent you also have to recognize that the CDC and the EEOC is saying practically that might not be realistic because some doctors' offices may be just overwhelmed with their ability to be able to provide timely doctor's notes. So you might want to consider alternative approaches there. So with that, I'm going to turn it over to Lindsay to cover the remaining sections of the labor and employment issue.
All right, thanks, Kara. So over the next few slides, we'll sort of touch on the other laws that have been implicated in this developing situation, and also to which we have actually received questions and the types of responses we have been providing so far. So the first one we'll talk about here is the Fair Labor Standards Act, so wage and hour considerations under the Fair Labor Standards Act. And as the coronavirus has become more widespread, we've definitely gotten a lot of questions from employers who, as a result, particularly in communities where there has been spread so far and there has been action taken to start, reducing the hours of certain locations, what they can and should do as far as employee pay. So, as many of you may know, the Fair Labor Standards Act does regulate wages for both exempt and non-exempt employees. And so the first question you'll see here is, must non-exempt employees whose work schedules are reduced due to a temporary closure be paid their regular schedule? Under the Fair Labor Standards Act, non-exempt employees only have to be paid for the hours that they work. So the answer to this first question would be no, not under the Fair Labor Standards Act. However, there are state and local laws that regulate minimum wage, that regulate how employers have to pay their non-exempt employees. And certain state and local areas also have what's called show-up pay, which means that employees have to be paid a certain amount of hours if they do show up for their regular schedule. So it's important that employers consider state and local laws as well, and also consider any collective bargaining agreements that might be in place and stipulations that those might create for how an employer has to pay a non-exempt employee. And then the next question there, must exempt employees like executives and supervisors be paid if they do not work due to a temporary closure? And this one is a little bit more dependent on the specific situation. So if an exempt employee works any portion of a work week, then the employer still has to pay them for the entire work week. So it's a little different from the treatment of non-exempt employees in that sense. However, if the temporary closure involves at least a full week, if not more, which we are likely to see going forward with many employers who have decided to close down for a certain period of time, at least, in the DC area, we've seen many preparing to close for at least 2 weeks. For that 2-week period where the exempt employee is not working any hours during a work week, the employer would not be required to pay them for that time under the Fair Labor Standards Act. So in addition to the Fair Labor Standards Act, another law that is implicated by the spread of the coronavirus is Title VII. So Title VII of the Civil Rights Act prohibits discrimination in employment based on certain protected categories like sex and race, which is important in this situation, as well as national origin, which has also become very relevant in this particular situation. So it's important going forward, and Kara kind of touched on this when she was talking about implementing a policy that permits the employer to take the temperature of employees, that all decisions made and all legal inquiries permitted under the Americans with Disabilities Act are applied consistently and aren't differentiated based on someone's race or national origin. In this case, we know that this particular strain of coronavirus originated in China and then spread to several other countries in Asia. So there may be inclination to focus on certain people of Asian descent in deciding, who to inquire further. But that is not permitted under Title VII, and that is not how these types of medical inquiries or the temperature taking, those types of policies related to addressing the issue of coronavirus should proceed. It has to be consistent, like Kara said, among a particular position or among a particular category of employees in the workplace. The CDC has actually addressed this issue and said that it is important to remember that people, including those of Asian descent, who do not live in or have not recently been to an area of ongoing spread, are, they create no greater risk than anyone else for spreading this particular virus. So employers should just keep that in mind in how they're implementing their policies and making sure, again, that is being done on a consistent basis to avoid any potential for violating Title VII. And then finally, a third federal law that we've seen implicated in this situation as the coronavirus has continued to spread is the Family and Medical Leave Act, or the FMLA. As many of you might know, the Family and Medical Leave Act provides 12 weeks of unpaid leave for employees who have to either care for themselves based on their own serious health condition or have to care for a sick family member. Employees with coronavirus who have been diagnosed with COVID-19 do likely qualify for FMLA, but those employees who might just be out of work because they're on self-quarantine or because maybe they've had some symptoms that tend to look like COVID-19 but maybe actually aren't, maybe don't manifest into a serious illness, those particular employees would not be covered by the FMLA. If employees are covered, then there might be some paid leave benefits that are available to them just through the employer's own policies. The employer has a sick leave policy, or the employer has other paid leave policies. Employees may be permitted to use that paid leave while they're out on FMLA leave, because that type of leave can run concurrently with FMLA leave. And then related to this concept of leave, many states and localities have their own laws as far as either paid or unpaid leave. So it's important when considering whether the employee can go out on a certain type of leave and whether the employee has to be paid for that period of time to look to state and local laws and make sure that you are complying with those as well. So going from the Family and Medical Leave Act, we are now going to transition into just a brief discussion on a bill that you may have heard about, just was passed by the House of Representatives on March 14th, and it's called the Families First Coronavirus Response Act. And this bill has only been passed by the House so far. It is with the Senate now, and they are considering any alterations to it before passage. So some of the provisions of the bill could change. But for now, this bill includes many things, but two of those things are paid sick leave and paid family leave. And the paid family leave would actually be passed as an amendment to the Family and Medical Leave Act. For both types of leave, the bill currently provides paid leave benefits for only employers with 500 or fewer employees. And under the paid family leave provision, employers with 50 or fewer employees actually will have the ability to apply for a waiver. So there is some consideration there for smaller employers. And in the next couple slides, we'll just go through sort of the main provisions of each of the paid family leave provision of the bill, as well as the sick leave provision of the bill. So under the paid family leave portion of the bill, again, like I said earlier, the Family and Medical Leave Act does provide for 12 weeks of leave, but under this bill related specifically to this emergency situation, the spread of the coronavirus, provides for 12 weeks of paid leave. But the first 14 days may be unpaid. So that will be up to the discretion of the employer if the bill is actually passed as it's currently written. But employees must be given the ability to use other paid leave during that first 14-day period if they choose to. The provision that would amend the Family and Medical Leave Act does say that employees will be eligible for this particular type of leave. So again, leave specifically related to issues associated with coronavirus or COVID-19. They'll be eligible if they've worked for the employer for at least 30 calendar days. And then going back to that initial provision, after the first 14 days, the employer is required to compensate employees at a rate of at least 2/3 their regular rate. So the way the bill is currently presented, employers do not have to pay the full regular rate of pay for employees who are out on this paid family leave associated with COVID-19, but they do have to pay up to 2/3 of the employee's regular rate. And then the last part of the slide here just shows the different reasons that an employee might be able to go out on paid leave under the bill. You'll notice that all three are specifically associated with COVID-19. The first is basically for the employee to care for themselves based on the recommendation or order of a public official or healthcare provider. The second is if a family member has been determined to be a risk to the community based on the recommendation of a public official or healthcare provider. And then finally, the last reason is for the employee to be able to take time to care for their child whose school or daycare may have closed due to COVID-19, which I'm sure many of us have been seeing in our own communities. And then under the paid sick leave benefits provision of the bill, the top part here again is the permitted reasons for this type of leave. So you'll see that these reasons are very similar to the paid family leave. You are allowed to use paid sick leave provisions to self-isolate, which is something, as I noted, related to the Family and Medical Leave Act, has not been a basis for taking protected leave or for taking permitted leave. So this particular part of the bill would allow an employee to recover pay for self-isolation. It would also allow an employee to be out on paid leave to obtain diagnosis or care for symptoms associated with COVID-19. It would allow an employee to take time to comply again with a recommendation of a public official or healthcare provider to care for or assist a family member. And then finally, to care for a child whose daycare or school has closed due to COVID-19. The paid sick leave benefits in the bill are limited to full-time employees. Sorry, let me rephrase that. They're limited to 2 weeks for full-time employees at 80 hours, and then 2 weeks for part-time employees based on the average number of hours they work over a regular 2-week period. Under the paid leave benefits, the employer does have to compensate the employee at their regular rate of pay. And then finally, the law does not explicitly preempt existing state and local paid leave laws. So again, as I mentioned, related to the FMLA, employers do need to be cognizant of state and local paid leave laws as well, as those might cover some portion of time off that an employee has to take related to COVID-19 as well. So with that, I will turn it over to Amanda to talk about some of the OSHA implications of COVID-19.
Great. Thanks, Lindsay. Hi, my name is Amanda Walker, and I'm going to start off by kicking off the OSHA portion, and then I'll turn it over to my colleague, Eric Conn. But OSHA has started issuing some guidance on this. This is not OSHA's first time dealing with infectious diseases. It's something that it's dealt with before. The last pandemic in 2009, H1N1, they were very involved in issuing guidance, and also issued some guidance with regards to the SARS epidemic. But this might be one of the pandemics that has had greatest impact in the workplace that we can all recall. So they have certainly been working on guidance. I think they continue to work on guidance, and they've issued guidance. So they have put up a web page dedicated to COVID-19. It kind of tells where the particular standards that might be applicable, and then also provides guidance. I think there's been a lot of confusion. We've received a lot of questions for employers. What are we supposed to do with regards to the current circumstances? OSHA's provided some guidance, probably not as prescriptive as some employers would like and laid out detail by detail, but it does certainly help us get a better understanding for where their mindset is and what their previous positions have been with regards to pandemics such as this. Turning to the next page, this particular OSHA guidance started to roll out in late February, early March. One of the more particularly substantive portions of their guidance was a book telling employers what they could do with regards to the workplace and measures they could take to protect the safety and health of their workforce. It largely follows CDC guidance. It kind of marries the CDC guidance with practical things that the employer can do in the workplace, such as social distancing, good hygiene practices, making sure that there's plenty of soap, tissues in the workplace, those sorts of things. And then also steps they recommend that employers can take to reduce workers' risk of exposure. It's important to note that this is guidance. There's not a particular standard requiring these steps, but OSHA could technically issue citations under the General Duty Clause, which Eric will talk about in a few minutes. So these are recommendations. I think taking some part of them is a good idea for not running afoul or an issue with any sort of OSHA issues down the road. One of the other things this guidance does, it divides jobs into risk exposure levels, high to lower, to help identify what sorts of precautions might be necessary for each job category. And then it also talks about what employers should do to protect the workers and give some examples. Steps to reduce worker exposures. The first thing that the guidance starts off by suggesting is that each workplace should implement an infectious disease preparedness and response plan. This is a plan that's going to basically, how do employees, who do they call when they're sick? What is the protocol going to be for when they are sick? How do you communicate to them what the workplace policy and expectations are? So that's one of the first things that comes out, as well as identifying what risk category of employees you have. Talking about the prepare to implement basic infection prevention measures. What happens if you have an employee in the workplace that is not feeling well, has a fever, and has some of the classic symptoms that we've all been reading about? Immediately moving them from the workplace and then having your set protocol on what needs to take place, which could include identifying their work area, who they've had contact with, where they've been in the office, so that you can take precautions such as cleaning, notifying other employees that they might have had close contact with. Develop and implement and communicate the workplace policies. This is what your expectations are with regards to sickness if they are having a temperature, not showing up in the workplace, just making it very clear to them. Some of the things that OSHA has recommended with regards to workplace controls in their hierarchy of controls, the highest in what OSHA likes to see most frequently is engineering controls, so there's no individual discretion with them or individual possibility for them to not be followed, is high efficiency air filters, increasing ventilation rates, installing physical barriers such as sneeze guards, especially for employees that might have to interact with the public very regularly. Then going on to your administrative controls, require sick workers to stay at home, virtual meetings, limiting the number of employees that are able to be in a meeting, implement telework if feasible, looking at job rotations and staggering shifts to minimize the number of employees that are at the location or work site at one time are also things that OSHA is recommending. And then going on to safe work practices, procedures to reduce duration, frequency, and intensity of exposures. Basically separating individuals, the meeting issue, requiring regular hand washing, providing plenty of boxes of Kleenexes and garbage receptacles to throw items away, providing hand and alcohol sanitizer for employees in the workplace so that it's easy and convenient for them to use, and encouraging them to wash their hands. And also personal protective equipment. Typically there is a requirement depending on your work site, and if personal protective equipment is required, you would have a PPE hazard assessment. It might be necessary to take another look at that to make sure that the new factors with regards to this virus are considered, to see if any new PPE is suggested or required. Also looking at CDC guidelines to see what's effective in the particular fact pattern would also be advisable. This is a category of the job tasks that I mentioned that came out in OSHA's guidance, how they are segmenting the different job categories from very high to lower. I don't think there's any surprise with regards to the categories that are in very high. We're talking about healthcare workers and lab workers that are doing procedures or administering procedures on individuals who are known to have suspected COVID-19. Such as aerosol generating, could be taking a nose swab, doing any sort of intubation, and then the morgue workers performing autopsies on bodies or known suspected COVID-19 patients. Those would be the very high categories. Within the high category, healthcare workers, support and medical transport exposed to known or suspected COVID-19 patients, and then also we have the mortuary workers involved in preparing the bodies. Then we get into the more medium task where employees are required to have frequent contact with the general public or people who may be infected with the virus or are not known or suspected, but who are not known or suspected COVID patients, which basically at this point could be the general public in the majority of locations throughout the country. Protections to consider. Moving on. OSHA has also issued some of these temporary PPE hazard assessment, which I just mentioned. A good idea to go ahead and consider that, whether gloves, gowns, respirators would be effective in the workplace situation. Once again, I think CDC guidelines are also a good practical point to help with that evaluation. In educating employees on good hygiene practices, reminding employees to wash their hands, providing sufficient soap and other alcohol-based sterilizers so that they can wash their hands. Signage could be another way to help with that. Sending emails to remind them to wash their hands. Require sick employees and guests to stay out of the workplace. Certainly have seen a lot of restrictions put on bringing guests into the workplace. I've even heard of employers sending out questionnaires in advance of allowing a guest in, making sure that they don't have any of the symptoms. Restricting access to areas within the workplace. Consider allowing expanding telework, which I think everybody's pretty much on board with, or a great number of where it can be done. It seems to be taking effect at this point. Provide adequate supply of alcohol-based hand sanitizers, cleaning supplies, and hand soap. With regards to cleaning supplies, I think it's important to note that EPA has come out with a list of cleaning supplies that will supposedly address the COVID virus and would recommend that internally you look to see if you're using those supplies, or you consult with your cleaning contractors to ensure that they're using those cleaning supplies, and at the very least they should be used in areas where you know that you have an employee who has a confirmed case of the COVID-19. We talked about significantly restricting limitations in visitors, discouraging the use of workers' phones, desks, office tools, and equipment, discouraging the use of other workers' phones. So if you have a receptionist desk up at the front and you're doing rotations in there to cover a lunch break for the general receptionist, it is generally a discouraged practice from OSHA at this point from having them sit in that area using the same phone without using any disinfectant to clean that material off before putting different employees in there. Provide customers and the public with tissues and trash receptacles, providing a means for them to contain any sort of nasal spray or cough and sneezing. Moving on to the next slide. The relevant OSHA requirements, as I mentioned to kick off this section, there's no directly applicable or subject-specific standard that deals with COVID-19, but we do have the General Duty Clause citation, or the General Duty Clause that Eric will talk about in more detail. But some of the other standards that have some applicability to the circumstances that are being faced in workplaces are the respiratory protection, especially in the healthcare setting, seeing employees ramp up what their employees have to do. Also, it's becoming a factor in manufacturing settings where they're no longer able to obtain enough respirators for the regular production since there's become such a shortage. Another one is the personal protective equipment, whether that be gowns, gloves, face shields, something else that can be part of the hazard assessment that employees are looking at and going to be requiring in some job categories. So that standard should be implemented, as well as the General Duty Clause and then the reporting and recording. So if there is a COVID case in an employee does come down and has a confirmation of a diagnosis of COVID-19, what do you have to do? Do you have to report that? Do you have to record that? And Eric will talk a little bit more about that, as well as the infectious disease standard that's been out on OSHA's horizon for a period of time. I think it started in 2010, and we don't have a final rule at this time. So turning it over to Eric at this point.
Thank you. I hope everybody can hear me better now. I'll look at the chat stream to see if there's any audio issues, but hopefully I addressed that. Yeah, as Amanda mentioned, there is not a specific standard that OSHA has promulgated that addresses airborne transmissible diseases. Many of you may be familiar with the Bloodborne Pathogen standard, which addresses types of illnesses that might be conveyed through blood and other bodily fluids. That does not apply to something like COVID-19 or the coronavirus. But OSHA has, for the healthcare industry, initiated about 8 or 9 years ago a rulemaking to address that standard or to address that concern for healthcare workers, and it has sort of languished in the beginning stages of the rulemaking process. Anybody who's dealt with OSHA or OSHA rulemaking knows that this process can take up to multiple decades to finalize a rule, and this is one that started almost 20 years ago, or almost 10 years ago, I'm sorry, but it has moved nowhere beyond even a request for information and is set on long-term action list, which is the essentially no action list for the time being, although with this current outbreak, there's been a lot of effort to try and get something going in that regard, even if it is just a temporary emergency rule. And the House Democrats have even introduced a bill that would require OSHA to promulgate a temporary emergency infectious disease rule. And there was talk that they were going to try to attach that to the House bill or to the legislation that would address economic relief and some of the other issues with this outbreak that Lindsay talked about earlier. Although apparently the White House signaled that they should remove that from their proposed bill, that it would not be signed if it was included, and it was removed, but it is still out there as an independent bill. This would require healthcare providers to develop and implement comprehensive infectious disease and exposure control plans, which I think most healthcare providers already do have, but it would set some criteria for what should be included in there to hopefully help protect our frontline healthcare workers. I mean, one of the major issues with battling this crisis around the world right now is that so many of the now infected COVID-19 patients are healthcare workers. They are the ones who are there, helping to treat patients who arrive with this illness, are catching the disease themselves, not surprisingly, but there are, very good practices, very good exposure control processes and protocols and tools and PPE that can be used, and that is the motivation for this rule, is to make sure that our healthcare providers or healthcare workers are given the best tools and the best, thoughtful planning to prevent that exposure, which is going to help all of us. On the next slide, we get into the standards that do exist that are relevant to this. And the main one that I think would be relevant to the issues we're dealing with here is OSHA's respiratory protection standard. And the first slide here talks about brand new guidance. I guess this is from 2 days ago. OSHA issued not guidance, but actual enforcement memo directing all of its field offices to provide some relief to healthcare providers in some of the respiratory protection requirements related to N95 masks. And the express purpose of this relief that is being offered is to address the significant shortage of N95 masks around the country right now, and the risk that our healthcare providers will run out of them, or what we are actually seeing, I'm hearing about from the field, is that they're being used improperly, being used for too long because they're afraid they're going to run out or that there's a shortage. And so the idea of this guidance here, of this relief that OSHA has offered, is to say that, right now, if you have a mandatory respiratory protection program, there is a requirement to perform annual fit testing for those respirators. And OSHA treats these N95 masks as respirators. And just to make sure everybody on the call understands the distinction between sort of a dental or surgical mask, which is basically just the cloth mask over the healthcare provider's nose and mouth, that's primarily designed to protect the patient from, a cough or a sneeze or something from, or spittle from the healthcare provider. The N95 mask is an actual filtering face piece. It looks kind of like the dental or surgical mask, but it has a filter built into, into the face of the mask that, has a filtering medium and protects the healthcare provider from aerosolized, strands of virus or anything else that might pass through the mask into the healthcare provider's mouth. Those masks are respirators, and therefore there's an annual requirement to fit test them. The fit test requirement is a destructive test requirement. Because this is a disposable mask, when you perform the fit test, it gets discarded. And so healthcare providers were saying, my God, we're wasting so many of these masks. Can we please get some relief? And OSHA granted that relief and said, there is a relaxation of the annual fit test requirement, but we are encouraging you to do other things, like instead of the quantitative fit test method that is destructive, do qualitative fit tests, or even better, to the extent you can, upgrade the quality of your mask from this disposable N95 to, a non-disposable half-face elastomeric, tight-fitting respirator that has the cartridges built in. So you don't have to dispose the respirator itself, and the cartridges last, quite a bit longer than a disposable N95 mask. So this is guidance specific for the healthcare industry, but it is more broadly applicable. I've already seen some questions in our chat function here, and I've gotten a lot of these questions from my clients, and Amanda mentioned this, that in general industry, if you have tasks that require masks or require respirators, and you have historically used N95 masks for those tasks, and you are having a hard time, as everybody in the country is, getting those masks, or you're seeing your supply being depleted and you're going to run out soon, one good option for that is to upgrade the mask, even if it's just temporarily during this crisis, upgrade to a non-disposable form of respirator so that your supply is not depleted after each use, that they can be used more often. Of course, if you do that, there is, it's a slightly more rigorous respiratory protection requirements, but at least you'll be protected from the lack of supply. And that's, of course, dependent on the availability of those half-face elastomeric masks. But my understanding is those are more available than the N95s now. On the next slide, which I think we could probably maybe even just skip over, this gives a few more ideas for what healthcare workers can and should do if they are taking advantage of the relaxed fit test requirements. The other sort of more common question that we're getting about respiratory protection is voluntary use respirators. So we've talked about already in general industry mandatory use respirators where, not for coronavirus, but for, dust or some other agent that you're protecting your employees from, and it's required. There is, on the flip side of that, voluntary use respirators. And here, if, you don't exceed a permissible exposure level for some toxic agent or dust or whatever it is, but an employee for personal comfort or their own safety decision asks to voluntarily use a mask, there are certain requirements that still exist. A, you've got to make a determination as an employer that that particular employee who is asked to voluntarily use a respirator can do so safely, that there will not be respiratory risks to the employee by wearing the mask. And then second, if it's purely voluntary use, you still have to make available to that employee and any employee who will use a mask voluntarily a copy of Appendix D of OSHA's respiratory protection standard. And that is basically just a little bit more guidance from OSHA about how to properly wear and use and maintain and respirators and things like that. So that's a requirement that you have to undertake. And we have confirmed that if you are allowing voluntary use respirators for purposes of this public health crisis, even though it's not a workplace, chemical or a workplace agent that will be affecting the employee, if you're going to allow voluntary use respirators, you still have to meet both of those requirements, even if it is because of this, this pandemic as opposed to a workplace issue. I'll clarify, because I mentioned before, the dental masks and surgical masks, things like that, those are not considered respirators. Frankly, they're not going to be particularly helpful to your employees, but if somebody decides that they want to wear one of those types of masks, none of these requirements apply. These requirements apply only to actual respirators and not those other types. So the next slide, I think, continues on this voluntary use issue. So a frequently asked question that we're getting, do I have to provide or permit use of respirators or these N95 masks as respirators if an employee requests it? We have also confirmed that there is no requirement for an employer to allow voluntary use respirators. Employees can ask for it, and historically, employers very commonly will grant that request if it relates to a, work-related condition, dust or something in the workplace, but you are not required to allow voluntary use of any respirator in the workplace. This, though, is getting into that category of potential general duty issues where if someone requests use of some sort of PPE and you decline it because it has historically not been necessary in your workplace, and there is some reason to believe there's a unique risk of contracting this, COVID-19, then you might have problems. And I think it either under the PPE standard, the respiratory protection standard, or the general duty clause, if there is a reason to believe that there is a unique risk in your workplace. And we'll talk about that here in just a second. But I think we've covered the respirator stuff pretty well. PPE, which would be, respirators are a form of PPE specific to respiratory protection. The broader concept of personal protective equipment, you are required and have been required since you opened your workplace to conduct a PPE hazard assessment to identify hazards for which PPE would be appropriate to protect against and to implement an appropriate PPE program. One of the things that we are generally recommending to our employees and that CDC and OSHA are also offering guidance about is doing that task anew, a new PPE hazard assessment, a temporary PPE hazard assessment to identify whether there are unique hazards of exposure to this coronavirus that would require the use of PPE. Are there tasks where people are uniquely exposed? For example, in a retail setting, your point of sale personnel who are handling cash, handling credit cards, if they're doing that, they might have a unique exposure to the virus on surfaces or personal interactions with employees, and you might consider whether PPE, gloves, or other protection may be required for workers in those tasks. The idea being, look at your workplace again with the thought process of, has anything changed about hazards, particularly about this illness that might require a different form of PPE than we've provided in the past, even if it's just temporary. And we definitely recommend giving a lot of thought to that. What do we have next? Record keeping and reporting. Yes, we're getting tons of questions about this. There is an exception in OSHA's injury and illness record keeping standard, or injury and illness record keeping regulation, that says the cold and flu are not required to be recorded on your OSHA 300 log. And the concept behind that exception is, they're so pervasive that it is, nearly impossible for employers to tell if the illness was contracted in the workplace or outside the workplace. So we are going to remove that burden from employers and say, you don't have to record cold and flu. OSHA has come out in guidance already since this outbreak began and said, COVID-19 is not part of that exception. It is not covered by that exception. So if you have a confirmed case and you make a determination that it is work-related, then, and it meets one of the recording criteria, it is required to be recorded. And similarly, if it meets the reporting criteria, it would be required to be reported. So it is not exempt based on the cold and flu exemption. So we've got a handful of questions here. We'll go through. The first one is kind of silly, just to set up the issue. If my employee knows that he contracted the virus outside the work environment, do I have to record it? No, there is still obviously a work-related component to making the record-keeping determination for COVID-19. So if someone is diagnosed, confirmed case, and that's a key issue in all of this, for all the questions we'll go through here, there must be a confirmed case. And confirmed case means you've gotten the test, and the test confirms that you're positive for the virus. It's not that you have exhibited all the symptoms consistent with the virus. I would say it's not even that you've exhibited all the symptoms and tested negative for the regular flu, or that your doctor says, well, there's a pretty good chance that's what this is. Unless you have a confirmed COVID-19 positive test, you're not a confirmed case. That's how they're tracking, how the CDC is tracking it, and the health departments are tracking it. Not a confirmed case, and if it's not a confirmed case, there is you can't distinguish it between cold and flu. So subject to the exemption, not recordable. You have to have a confirmed case, then you have to determine work-relatedness. If they know they picked it up outside the workplace, then it would not be recordable. On the next slide, we get into the tougher questions there, and that's same question. Employee has a confirmed case now, but the employee either believes it was contracted in the workplace, or there's just no information about how or where it was contracted at all. Is that recordable? The answer is maybe. I think it is, in most circumstances, probably not. You have to determine, just as you do any other injury or illness, on a case-by-case basis, whether it is more likely than not that an event or exposure in the work environment caused or contributed to the illness. So the assessment is it 51% or more likely that the employee contracted this virus in the workplace? So you've got to look at the circumstances. Is there someone else with a confirmed case who's been in the work environment, whether it's a coworker, a guest, a patient, whatever your workplace is, where someone might be, and is there reason to believe, based on the work activities of this new confirmed case employee, that they interacted with that person or interacted with a tool or a work area in common with that employee? And then look outside the workplace at community issues. How many confirmed cases are there in the community? Is there any, as much likelihood that this person interacted with someone outside the workplace who is a confirmed case, and make that judgment? And frankly, I think it is just going to be extremely difficult to identify the likely cause, or more likely than not cause, of where someone contracted the virus to connect it to the workplace, except for, where I think this is probably most likely to be applicable, is for healthcare providers who are working with confirmed cases. There are patients with confirmed cases of the virus. So if you've got healthcare employees, I think, objectively speaking, you might deduce that it is more likely than not it was a workplace exposure. Or you look at these nursing care situations where multiple residents and patients, and then multiple of the staff at the nursing care facility are contracting the virus. If you see something in the way of a cluster, it is much more likely that you could reach a reasonable conclusion that it is more likely than not that the work-related, the work environment caused or contributed to the illness. I think that's it on that slide. I think there's a couple more recording issues. Now we move on to reporting. And if if this is part of your responsibilities at work, we've got to determine whether we record an injury on a log, but also have to determine in some instances whether we pick up the phone and call OSHA about this. The analysis, it's under the same exact regulation. The analysis is almost the same. You are still figuring out, is it a confirmed case? Is it work-related? And then you have to look to see whether there is whether it meets one of the reporting criteria. And the two that would be applicable here are inpatient hospitalization or fatality. But one thing that leads me to believe that it will be rare, if ever, that a COVID-19 case is actually reportable to OSHA is the timing requirements of the reporting rule. You must report to OSHA inpatient hospitalization of a single employee for work-related injury or illness, but you must do so if the employee is admitted to the inpatient service of the hospital within 24 hours of the underlying exposure that caused the illness. As we are beginning to understand the epidemiology of this illness, it sure looks like people have the illness. The exposure occurs quite a few days before symptoms appear and before someone would even know to go to the hospital to get checked out, and before those acute respiratory issues kick in and someone gets admitted to the inpatient service. So it seems unlikely to me that we will have a case where you have within 24 hours of whatever the exposure was at work that you determined caused it and an inpatient hospitalization. In terms of fatality, right, there is seems to be a high mortality rate for this illness. A fatality must occur within 30 days of the underlying contraction of the illness, of the underlying exposure in the workplace that caused the illness to be reportable to OSHA. I suppose that's more likely, but probably still, I think, less likely than other types of workplace incidents. So I don't think there'll be a whole lot of reporting here because of the challenge to connect work-relatedness, but also because of these timing issues. I think we've got one more record-keeping question here. Yes, and this probably is one that you're going to tackle more often. If one of your employees you determine is exposed to the virus while traveling abroad, outside of the United States and its territories, and it contracts the virus in a work-related experience, they're at a conference, they're engaged in work overseas, and it seems clear enough that it is work-related, but it's outside the U.S., is that recordable or reportable? And the answer is no. OSHA's got a good bit of guidance on this, not in the context of COVID-19, but about other illnesses. I think there's an FAQ from OSHA on this page that's about tuberculosis. And here you're only required to record and report injuries if they occur within the geographic coverage of the OSHA Act and its regulations, which applies only within the U.S. jurisdictional boundaries. So the initial case of this employee overseas would not be recordable or reportable, but that could be the employee who comes back to the U.S., is back in the workplace, later realizes they have the illness, and you get the second case. The second case may become recordable by an employee in your U.S. workplace who's been exposed to that coworker if all those other elements are met: confirmed case, work-related, and meets one of the recording criteria. One last thing on record keeping that we've been asked about is the employee who sort of and we're moving past this, I think, where we're all going to be, if to the extent feasible, teleworking, but the employee who self-quarantines out of concern, maybe they were with or near someone with a confirmed case, so they stay at home for 14 days. Hey, is that a days away injury that I have to record? You only record if there's an actual illness. There needs to actually be symptoms of an illness for there to be an illness to record. So self-quarantine, self-isolation would not be a days away injury or illness without an injury or illness. So that's the answer to that question. All right, the last thing is the general duty clause, and I'll just be very brief on this. The general duty clause, as many of you hopefully know, is OSHA's catch-all requirement. And here, where there is no specific OSHA standard, which is pretty applicable in this circumstance, OSHA can still bring enforcement if an employer does not undertake enough action to provide employees with a place of employment that is free from recognized serious hazards. So the key there is that there is a recognized hazard, and it's not enough to just say there is this virus out there that is particularly lethal and, you know, it's around us. There needs to be a unique hazard in your workplace. Generally speaking, historically, there has to be a unique exposure, a unique reason to believe there is a hazard in your workplace. And that, you know, might, certainly in the healthcare industry, I think OSHA would comfortably establish that threshold. In other workplaces, you might be, you know, it wasn't a recognized hazard until after the first case cropped up, and then it became so. Or if you have work tasks that require a lot of interaction with the public, there's probably, I think OSHA could establish a recognized hazard in that circumstance, so you've got to take actions. And those actions are the kind of things that Amanda was talking about earlier from OSHA's guidance about engineering controls to consider, admin controls to consider, safe work practices, and PPE. That's your way of, you know, acting reasonably in response to this recognized hazard and doing, you know, the things that are following guidance from OSHA and CDC are a good way to say we did the reasonable and responsible things that employers are asked to do in recognition of this hazard, and that's where I would kind of leave that for now. I expect we'll have some questions. And I think the last slide goes, one more interesting bit here. This is a question we've gotten where we are depending on third parties to help with certain regulatory requirements to meet certain regulatory deadlines. The examples we've gotten questions about are, you know, we do every 3 years a PPE, I'm sorry, not PPE, but a PSM compliance audit at our PSM covered facilities. And on the encouragement of OSHA and EPA, we've been using third parties to do that. Well, the third party auditor canceled on us because they've got travel restrictions or they're in one of those suspect classes where it's higher risk, so they would not make the effort or the travel to participate in that. PHA deadlines that are coming up where we can't get employees gathered in a room or shouldn't have employees gathered in a room to undertake that activity. Annual lotto inspections, things like that. Is OSHA going to rigorously enforce these deadlines when we've got this crisis? And this is just our assessment based on our understanding of how OSHA operates in times of crisis like this, after hurricanes, tornadoes, other natural disaster type events. Likely OSHA is going to cut you some slack if you act in good faith. And then sort of start with the last bullet. Don't just sit on your hands and cry, pandemic, we can't do it. Do something. And that something is, you know, document why you're not able to meet the regulatory requirement by the specific deadline. Demonstrate, you know, by documenting the good faith efforts you've taken to, you know, we were going to address that. We had the schedule, we had the people signed up, we have a contract, and they broke the contract. They said they couldn't travel, they can't be here. And then look to see if there are interim things that you can do to address whatever that requirement is until you can really, meet the full requirements of that regulatory requirement. You know, we talk about, like, for PHAs, we can't do a full PHA, but we could get, you know, a couple of people together to review MOCs over the course of the last year and incident reports over the course of the last year, and any, you know, big changes in throughput or major operational changes, and make sure that we're giving the, you know, careful thought to whether that would affect safety and health, which hopefully you were doing anyway. But, you know, do basically a PHA light to the extent you can until you can get the team together to do a proper PHA. So my expectation is that we will see a little bit of enforcement discretion exercised by OSHA in the wake of this if you can demonstrate good faith and some effort to implement interim measures. And so I think that was my last slide here. Yeah, I think Lindsay is going to talk to us about retaliation.
Sure. Thanks, Eric. So yeah, the last point that we wanted to make related to OSHA and the OSHA implications of the spread of this virus is Section 11C, which is the provision of the OSHA Act that prohibits employers from retaliating against employees for certain safety-related activities. I think a lot of times where the Section 11C or the whistleblower provision of the OSHA Act are implicated is where there's an employee complaint made to OSHA and the employee asserts some level of retaliation, or a safety complaint is made to the employer, and as a result, the employee asserts retaliation. And those are, potential outcomes here as well. We do know that there have been some employee complaints made to OSHA related to COVID-19 and the coronavirus in the workplace. But one of the ways that we see that Section 11C could be implicated in the current environment is where an employee refuses to work because the employee believes in good faith, and that's an important requirement for an employee's refusal to work, that there is an imminent danger in the workplace because of the fact that one of their coworkers is sick and has been diagnosed with COVID-19, and there is insufficient time to eliminate the danger through resort to regular statutory enforcement. So employees are permitted to assert that a refusal to come to work due to imminent danger. Again, that there needs to be some reasonable basis for this belief. The employee has to believe this in good faith. But if, an action is taken against them because of that, and there is a reasonable basis because maybe a coworker has been diagnosed who they work closely with, and they believe it in good faith, they could potentially have a Section 11C protected activity and a basis to make a complaint to OSHA. So I think to just cover this briefly, that's just something to be aware of, something to consider, and something to keep in mind when evaluating potential responses to employee actions, such as making a safety complaint or refusing to come to work related to COVID-19. Generally, the employee will not have a good basis to refuse to come to work because of COVID-19, but there are certain circumstances where that could be reasonable good faith belief. And then I will turn it back over to Kara to close us out by reviewing some of the CDC guidance and best practices.
Thanks, Lindsay. So yeah, we've got, CDC has been issuing guidance, as we've talked about. A lot of this stuff we have already discussed on our presentation, so I'll go through these relatively quickly so that we have some time for questions. We've gotten lots of them, but again, you want to make sure you're encouraging people to stay home if they're not feeling well, having flexible sick leave policies and making sure your employees are aware of those policies if you need to update them, separating sick employees and sending them home immediately. Again, instructing employees how to clean or wash their hands and making sure that you are providing the right supplies to make sure that people are engaging in appropriate hand sanitizing procedures. You may need to perform routine environmental cleaning, and I know one thing we have not talked about today, but we've gotten some questions, is what happens if there is a potential positive test in the workplace, and how do you make sure that you are properly cleaning the workplace. You really want to, frequently touch surfaces. You want to make sure your employees are cleaning them. Workstation, countertops, Amanda talked about if you've got the issue of people remote working or changing locations in light of new schedules, you want to make sure you're wiping those down for the next employee. Commonly used surfaces within your workforce. With respect to travel, I don't think a lot of people are traveling internationally, certainly, but you should make sure that employees should be checking the CDC's travelers' health notices. And then employees who are well but who have a sick family member at home with COVID should notify their supervisor and then refer to the CDC guidance on how to conduct a risk assessment of their exposure potential. We've gotten a lot of questions about what happens if someone feels like they need to then be self-isolating for the quarantine period of 14 days because they've been in close contact with somebody. What do we then need to do at the workplace to notify the rest of the employees? Again, you want to keep employees' information confidential, but you want to think through that workplace. Where has that individual been working? You can ask that individual questions as to where they have traveled through the workplace, and then you need to think about whether you need to decontaminate that workspace, or do you wait to see if that individual ultimately tests positive before you do an environmental cleaning and decontamination of that space. So it depends on the circumstances and depends on that, but in terms of disclosing a coworker's self-isolation, self-quarantine status to other coworkers, our recommendation is that you do not disclose the name of a coworker, you keep that confidential, and you do what you can to protect the workplace as necessary. With that, I want you to remind everybody that we do have our blogs. We are updating our blogs regularly on these topics. We just posted yesterday on the EEOC's guidance that I mentioned. So this is a really good resource for you to get some up-to-date Q&As. If we haven't answered your question today, go back and look at some of our recent blogs. I saw some questions about how you can pay employees, exempt employees, for reduced work, whether it's a 4-day work week or reducing their exempt salaries. We have answered some of those questions in our recent blogs, so please go check that out if we didn't cover your topic today. And then going forward, we'll be conducting our virtual webinar series probably for the foreseeable future or the next few months. We've got a lot of good topics coming up, both on the labor and employment and on the OSHA webinar series, so please take advantage of that as they approach, but really want to spend the next 20 minutes or so answering questions that have come up. And I think I am able to access an email that has everybody's questions. Let me see if I can do that. And I will circulate some questions around to the group. Let's see. Any reporting obligation to the CDC? That's an important question. The healthcare provider who's going to do the testing and get a positive COVID test, they are a mandatory reporter. So they will report that diagnosis to the state health department and to the CDC, and they will work with you as the employer to help you navigate what you need to do next in terms of contact tracing, where that employee was in the workplace, outside of the workplace, who they came in contact with in the workplace, and they will partner with you to help you put a plan together to mitigate further community spread in the workplace. So know that you are not required to report to CDC, but the healthcare provider would. Let's see, a lot of questions about respirators. Eric, if an employee requests a respirator, does the employer have to provide it?
Was that if the employee requests one or wants one? Was that the question?
Yes.
Yeah, so I think we covered that a little bit, that there is, if it is voluntary use only, then you are not required to allow them to use it. And so that voluntary use it's a regulatory term. That means it's not required because of a known hazardous exposure in the workplace. So that would mean if you have, chemical agents that have been tested to be at or above an action level or permissible exposure level, that would be required use. Or there are circumstances where an employer just says, I'm going to require it. Even if you are exposure levels below the PEL or the action level, if the employer declares that it is required and mandatory, then you must provide the respiratory protection, and you must meet all of OSHA's respiratory protection requirements. But if it is purely voluntary, and we certainly understand why an employee in this time might say, I want this, the employer has the discretion to say yes or no. But again, you want to consider in those tasks where an employee is interacting considerably with the public, then it might move into that category of required use based on the, your community and the interactions that your employees are having. But as a basic level, if it's voluntary use, you are permitted to say no.
Okay, thanks. A few questions, Lindsay, for you about the federal legislation that's pending. We know it's still pending in the Senate, hasn't made much movement, so there could be some changes right now. But are the paid sick leave benefits in addition to what employers currently provide under PTO? So right now, let's say an employer only has 7 days of PTO benefits, but the federal legislation provides for 2 weeks. Is that in addition?
So I'll kind of preface this with, we don't have a lot of information as of this point about how exactly the specific provisions of the proposed bill will apply. And I'll tell you guys that since we've been on this webinar, I believe there's actually, it's come out that there are already changes being made to the bill that was passed by the House. So the House is already making changes to the bill that they passed to try to conform, I think, to some of the Senate concerns and hopefully get the bill actually passed through both houses as soon as they can. One of those changes potentially is caps on the paid sick leave. It's supposed to be paid at the employee's regular rate of pay, but they are potentially going to have a cap on that amount. So this is sort of still an evolving bill. It's still evolving as to what the specific provisions will be. But my understanding for how this would apply is if the employer is already providing some amount of sick leave, whether it be pursuant to their own policy or state and local law, that they would continue to provide whatever, if they provided 7 days of paid time off, then they would just apply those 7 days to the first 7 days of the 14-day period, and then be required potentially under the federal law to provide the regular rate of pay for the remaining 7 days thereafter. But again, this is changing, and so as the law gets finalized and actually passed through both houses, I'm sure there will be some guidance that kind of goes along as to how this should actually work in practice.
Okay, thanks. So everybody stay tuned, particularly to our blogs, and we'll be certainly blogging. We have an article already about the federal legislation, but we will update it as any changes are made. Several questions about taking employees' temperatures. Certainly, if you are going to take your employees' temperatures, I said it should be across the board. And so if you do it for all employees, that's consistent. Although you really should have a reasonable basis that there might be a reason that the employees might be facing a direct threat in the workplace. So if you have a confirmed case of COVID in the workplace, that would certainly be a reason why you would be checking all employees' temperatures. But if there's been no risk or no reporting or nobody has even reported that they've come in close contact with, I'm not sure if you have a reasonable basis to conclude that there's a direct threat. But if you are going to do it, you want to make sure you are following guidelines with respect to privacy. As I mentioned, it is a medical exam protected by the ADA, and so you want to the extent you're recording or keeping any of that information, you want to keep that in a separate medical file. And otherwise, just, if you're just taking a temperature and you're not keeping it, then there's no documentation. But you do want to keep it private. If someone does have a high fever and you send them home, similarly, that is information you want to keep confidential and private. Let's see. Question maybe, Eric, for you about OSHA's recent enforcement memo exempting annual fit testing for the healthcare industry. If we have work tasks that require respirators, does the exemption apply to us even though we're not in the healthcare industry?
So the answer is no, right? I think that by its express terms, the enforcement memo is limited to the healthcare industry, and the purpose is to make sure that there's enough masks available for healthcare workers. But I would say, I think you would probably hopefully would find a reasonable regulator on the other side of a discussion about that if you are doing it for the same reason and you are doing the other things that the agency recommends in that guidance memo, like doing a different kind of test so that there is at least some effort is being made to evaluate the fit, that a fit is proper and that the seal's not broken, and that employees know how to do it correctly, how to don and doff correctly, and some of the other aspects of that guidance as well. So by its terms, it doesn't apply to anyone outside that healthcare setting, but I think if you follow the guidance and you make a similar showing that, hey, we did this because we've got required use respirators here, required use masks, and we're running out and we can't get any more. And so rather than doing destructive tests, we did these other kinds of tests and other kinds of the decisions about respiratory protection, consistent with your own guidance to the healthcare industry. I think you will hopefully find, as we did after big hurricanes and other issues like that, a receptive agency. But technically, the answer is no.
Okay. Some questions about layoffs. If you're going to consider a layoff so that individuals can go get unemployment compensation during this time period, think about the scope and size of that layoff. If you have more than 100 employees and you are thinking of laying off more than 50 employees at a single site of employment, and that the number also equates to at least 33% of the workforce, you may have to comply with the federal WARN Act. WARN also has several iterations across the states that differ and may provide for greater coverage. And generally what WARN provides is you have to give written notice in advance to the employees and other individuals and state agencies of the mass layoff. However, under federal law, under federal WARN, a mass layoff is not, or WARN is not triggered if a mass layoff is less than 6 months. So we've been working with a lot of companies over the last couple of days who have been doing mass layoffs. However, they are telling their employees that it is not going to be longer than 6 months. Obviously, right now we don't know what the circumstances are, but if you want to try and classify it as a temporary layoff, you should do so and make clear to the employees that it's less than 6 months. If you have to have a business closure entirely, that could be considered a plant closing, and there could be WARN notice requirements as well. So just be aware that there are some notices that could be required depending on the length and the nature and the scope of your business. A couple questions about what types of companies are considered essential under the various stay-at-home orders that are happening around the country. I would encourage everyone, if you are in a location like Miami or San Francisco or New York or other locations that have implemented those orders in the last couple of days, to look at that. Each definition is a little bit different, so it's unclear always what is defined as an essential company and able to do business. So I would encourage you just to look at your local order. Let's see. A question about, again, a lot of questions about people who are self-isolating or being tested and the disclosure requirements. If an employee who are sent home tell others in the workplace that they're being quarantined, is the employer still not obligated to disclose their names when others tell other employees? I mean, what employees tell their coworkers you can't control. It's really from the ADA confidentiality HIPAA requirement. It's really what the employer discloses. So if the coworkers talk amongst themselves and the name gets around, there's not much you can do about that. But you certainly want to, from an employer management perspective, you want to be proactive and not be sharing that information around the workplace. Same thing if you've got employees that are saying, hey, Joe Brown is sniffling over there and I don't want to work next to him, or I'm afraid that Sarah is running a fever, you know, I don't want to work with them. What steps can you do? Again, you want to really encourage your employees and educate your employees about, you know, keeping things confidential and not presuming or assuming anything about other people. One of the aspects of the ADA that we haven't talked about is the perceived as disabled, and you really just don't want your employees to be, you know, gossiping or rumoring about the health conditions of their coworkers when someone could just be recovering from allergies. So just do what you can to educate and communicate with your workforce so that everybody is being protected. There was a question, can a healthcare worker, and I really think arguably, or any worker, opt out of work duties based solely upon their belonging to a high-risk group, such as age, or maybe they have a compromised immune system, or because they think that the workplace is unsafe?
Yeah, I mean, I think from a Title VII perspective, if they are voluntarily asking for some limitation because of concern related to COVID, there's not a concern that the employer is necessarily acting in a way that would violate Title VII, the Age Discrimination in Employment Act specifically, which protects employees over the age of 40. So I think that the employer can sort of consider the circumstances, consider, the basis for this request, whether it's reasonable, and work with the employee to ensure that, they feel safe in the workplace, that they can perform their duties without feeling like they are necessarily at risk of being exposed as a higher risk portion of the population. I don't know if there's anything else you want to add to that.
Yep, no, I think that's good. One question is, can employers advise employees to self-quarantine just because they've been on an airplane? I think here what you want to do, because we are in a pandemic situation, you can ask the employee where they traveled and where they, whether they came in close contact with somebody because of the, their travel or being on the airplane. And if someone is exhibiting symptoms and they want to self-quarantine, it's up to the employer whether you want to allow them to do that for 14 days. If there's an opportunity to do remote work during that self-quarantine phase so that they may not be out of income. But if you don't otherwise have a reasonable basis to believe that someone has been, in close contact with somebody or returning from a location that is high risk, I would not recommend that employers require employees to self-quarantine if they're not otherwise exhibiting symptoms. The best way to send employees home is if they are displaying the influenza-like symptoms during this time. Okay, so it's about 4:18. I want to emphasize to everybody on the call that I know we didn't get to everybody's questions, but we do have a log of them, and we will do our best to respond to you. We will be circulating the slides after this call to everybody who has registered, and we will also be sending a link to the recording later this week as soon as we're able to, format it and do it technologically. But both resources will be circulated to everybody. And again, if you have any other questions that haven't been addressed or come up after this call, please don't hesitate to reach out to any of us, and we hope that we can be a resource. And hopefully I can say on behalf of our entire firm, please be well. We're thinking of you. We're thinking of all of you, our clients, your staff, just how this is affecting, and we're here to partner with you to answer your questions and be a resource and do what we can to sort of mitigate some of these legal risks over the long term. So thank you for participating, and we look forward to talking with you or seeing with you on a future webinar or in-person meeting. Thank you.
Thanks, everyone. Bye-bye.